I'm Emanuel Rose, and I'm here today talking with Patrick Johnston from 3F Captive Services and Tony Raimondo, who is an attorney in and an expert in labor law I think, in California, but I'll let Tony introduce himself.
I've been an attorney for 25 years in California, and I'm actually now licensed also in Oregon and Washington, specializing in labor law and other areas of business law related mostly to agriculture.
And Tony, how did you get involved in the farming industry?
Honestly, as a young lawyer, I kind of fell into it. I was practicing criminal defense in Fresno, California, and wanted to get out of that business, and stumbled into a job at a firm that specialized in it, and it just clicked and went from there.
And that was 25 years ago?
Yeah.
Well, I'm sure there's been a shift over the last 25 years in terms of labor law. Do you want to just talk big picture about what you've seen through your career?
I would say that the two biggest things that have changed are that generally the political and legal environment for employers in California has gotten more and more hostile over time, and more aggressively anti-business over time. So it's become a minefield for employers to navigate the very thick labor code, as well as the various anti-discrimination laws, wage and hour laws, workplace safety laws, all the various things that California does to regulate the employment relationship. But in the litigation arena, the real big change has been when I was first starting out, there were very few class action or collective action lawsuits brought under the California Labor Code for a variety of what we call wage and hour violations, which can be record keeping like time clocks, or they can be substantive claims for unpaid wages and various other things. Over the years, these collective actions in the form of class actions and then what we call Private Attorney General Act actions have grown really exponentially. Somewhat due to not only California's unique legal environment, but also because we passed a unique law in California called the Private Attorney General Act. Actually, a long time ago in 2004. And it kind of, people didn't really jump on the bandwagon right away, but once attorneys figured out what they could do with it, it became very, very popular in one of the most high growth areas of labor litigation, which is where an individual steps into the shoes of the state of California as a law enforcement officer. The labor code is full of lots and lots of kinds of penalties for things, record-keeping violations, technical violations, substantive violations. And there's two kinds of penalties. There's penalties that go to the employee, that the employee can collect for themselves. But there's other kind of penalties that are like the tickets you pay if you drive too fast or you run a stop sign. You pay that to the government. Well, these Private Attorney General Act actions allow an individual employee to act as the government and enforce all the various penalties in the labor code against employers. They have to give a percentage of that to the state. Then they give a percent, they distribute a percentage of it to the employees, but they also collect their attorney's fees. In practice, these claims have become a way to essentially shake large amounts of money out of employers. The invariable end of these types of claims is employees get a distribution of some very small amount of money. The state gets a little piece of money, and the attorneys take a very generous attorney's fee, which will be 30 to 40% of the overall pool. Because the overall pool will sound like a lot. Let's say the overall pool is $1 million. Well, right off the top, the attorney's fee is based on 30 to 40% of that $1 million. So let's take 400,000 right away and push that over to the attorney's pile. Well, then there's usually some sort of claims administrator who administer the distribution of this money. Let's take 25,000, push it over to them. It'll usually take a mediator to settle these cases. These mediators now, $10,000 to $20,000 a day for mediation. So let's put $20,000 to a mediator. You notice we haven't given any money to employees yet. Well, whatever's done when they take all these fees and costs out, 75% goes to the state of California, and then 25% is going to be distributed to however many employees there are. The real perversion that occurs in these cases is what it does to the legal profession, because there's a whole industry that has sprung up around this of plaintiffs and defense attorneys as well as mediators. For defense attorneys, the numbers in these cases are so high, usually out of the gate, people asking for millions of dollars. It's not hard to convince a business they need to spend money to fight that. The vast majority end up in negotiated settlements done with a high dollar mediator, a high dollar claims administrator. All these things cost money and they create an industry. But the incentives for plaintiffs' attorneys are all upside down. Let's take, for example, a discrimination or a sexual harassment case. Normally, that'll be done on a contingency fee. Say I'm representing you in such a case. I'm going to take 30 to 40% of whatever I get for you. The only way I get more money for me is if I get more money for you.
Right.
Those are properly aligned incentives for me as an attorney, right? Well, in these cases, and the class actions will also fall into this, although there's more employers can do to protect themselves from the class actions. It's been very many years since I've done a mediation where there's even an employee in the other room with their attorneys. The attorneys are usually authorized to negotiate these settlements on their own. They rarely even bring employees to those negotiations. They just tell employees what the outcome is, or sometimes they claim they have them available by phone, which I'm skeptical of. We're expected to have our clients there, the business folks there, but we rarely see employees involved in those negotiations. And the driving factor in those negotiations is not what the employees are going to get at the end of the day. It's all about the attorney's fees.
Yeah.
You can see it happening in the course of those negotiations, where what you're really looking for is you're trying to figure out, well, what's the number we can come to that's going to secure these attorneys the amount of money that they want to settle this case. Those are upside down incentives for lawyers, and it's a really, I think, a corrupting factor in the legal profession. Because
I think that we would both agree with you on that. But that's not going to change in the state of California anytime soon. Am I correct in that assertion?
No, there's some things that are going on with the Private Attorney General Act in particular. So the thing you got to remember about the Private Attorney General Act is that's all about penalties, and it's all about penalties that are normally collected by the state. Again, think of it as collecting traffic tickets for the state. The class action side of this, which is also where one employee represents the interests of other employees, is for claims on behalf of the employees themselves. For example, if they have unpaid wages, that part falls into the class action side of it. And then there are other types of penalties that are consequences employers have to pay if they don't pay wages correctly or for some other things that are set forth in the labor code. Class actions, employers have a lot of risk management tools like arbitration agreements that can actually prevent employees from pursuing claims on a class action basis. As of the state of the law right now, arbitration agreements are no protection against a Private Attorney General Act claim. But what happens with a Private Attorney General Act claim is they figure out how many employees there are and how many pay periods there are over this period of time covered by the case. And they just figured out they figure out a dollar figure per employee per pay period, and that's what they demand from the company. And sometimes their initial demands are insane amounts of money, where you almost laugh when you get the demand, because you're like, wait, no one has that kind of money. I mean, who has that kind of money?
Yeah, it's the kind of money that puts businesses out of business. It's not based on reality.
But it's really just a shakedown approach, where what you figure out as you whittle down through these cases is they're just trying to make sure they're not leaving any money on the table. They're trying to figure out what's the maximum they can extract from this particular business in this little leverage game of these very expensive and complex pieces of litigation. So you mentioned, is it changing? Well, there was a ballot initiative on the ballot that was supposed to be for this November, which looks like now it's going to be withdrawn. And that ballot initiative, while it's short of a full repeal of PAGA, which is what I would prefer, it certainly was a much better step in making these cases more difficult to bring and disincentivizing them. It obviously got the attention of some folks because there were some backroom negotiations in Sacramento between the governor, the California Labor Federation, I believe both plaintiffs and defense attorney groups, and Chamber of Commerce, some of the bigger business groups. And they agreed to a compromise. I think this initiative is going to be pulled off the ballot, and there's a reform package that the governor is going to sign that, from what I've read about it so far, looks to me like the illusion of reform. You know, they're going to change the amount of money that gets distributed to the percentage that gets distributed to the employees to be a higher percentage. The problem is, if a private attorney general act case is brought in conjunction with a class action, typically the parties will negotiate what are the penalties and what are the class action wages and such, and they'll push a smaller amount over to these penalties so that they can manipulate the numbers to spit out ultimately the attorney fee award that needs to spit out of this to make the deal work.
Interesting. Because
these things are very, very rarely litigated to a complete conclusion. So I don't think it's going to, this supposed reform is going to change the dynamics of this, where basically these things are just a profit generating measure for attorneys. In the end of the day, 99.9% of these cases end with employees getting a very small amount of money and attorneys getting a very large amount of money. And I say that attorneys on all sides.
Yeah. So then what is the threat that exists with PAGA and the family farms in the state of California right now?
Well, the problem is that PAGA is really, it's all based on the California Labor Code, which has lots and lots of very technical requirements to it. We've seen PAGA cases brought, for example, over an employee's time record shows that they were punched out for 29 minutes instead of 30 minutes for lunch. I mean, literally over mere minutes. Time clocks that are programmed, mathematically programmed to round up or down to the nearest 15 minutes, being deemed unfair and threatened with these massive avalanches of liability. So there's all these little technical things which, you know, for smaller family farms are very difficult to comply with. I mean, for people who aren't in the industry, it's hard for, I think, people in urban areas to imagine that, you know, we still have guys keeping time records by pencil on little cards.
Right.
You know, we have folks for whom a mechanical punch clock is high tech. So these folks are very vulnerable to this. And part of the problem is there's no commercial insurance available that covers this type of risk. There are very limited policies, although I see them very rarely now, that may provide some attorney's fees coverage, but usually not very much. And those policies tend to be very expensive. I tend especially not to see our small and mid-sized employers have those type of policies at all. So it's difficult. If you think about this in farming terms as a horrific weather event like a tornado, right? A tornado might hit your place and leave your neighbor untouched.
Right.
Well, but that's no solace to you, right? You can purchase insurance against that catastrophic event. You've got to think of these things as a catastrophic event that it may never hit you. You may never have that tornado hit your ranch. But if you do, you're going to be glad you have some reserve emergency fund against that, so that if that catastrophic event occurs, you have the ability to deal with the cost that it represents. Because although there's lots of ways you can protect against these cases, of course, having a relationship with a good labor attorney who can help you with the compliance side of it, you can protect yourself in a lot of ways. But I hear attorneys and HR people all the time telling companies, we can give you 100% protection. We can bulletproof you. In the environment in California, I don't think that's possible. I really don't. I don't think that you can create 100% protection against these risks, right? Just like we can't create 100% protection against weather-related risks.
Sure.
So what do? We protect ourselves against the ability to withstand the consequences of those risks. Unfortunately, for these wage and hour claims, these collective action claims, those products don't exist in the commercial market.
Yeah. So what are some of the other unforeseen risks that you're seeing in these wage and hour cases?
Typically what we see is claims regarding off the clock or unrecorded work time, meal breaks, rest periods. There are technical requirements for people's check stubs. So one of the things we've been promised with this reform is, oh, if one of these things come up, you're going to have the opportunity to fix it before you're liable for it, which is a promise that has been made a bunch of times in connection with PAGA over its life. As they've tinkered with the statute over the years, they've created what they call opportunities to cure, which have done nothing to slow down this litigation. So I'm really skeptical of that. It's one of those things that sounds good when you say it on the news, but in practice, I don't think it makes a significant difference. So typically what happens is employees have a right to get copies of their time and payroll records. An attorney will send a letter with a signed authorization from the employee to get those records. And then they comb over those records to look for technical violations. Those technical violations spawn the PAGA claim. And now the employer's faced between spending lots and lots of money. I mean, it can be easily $10,000, $20,000 a month for these types of cases in attorney's fees just to defend themselves. Or do they try to figure out a way to negotiate a settlement where they get themselves out of it, which becomes a leverage game. It's almost a form of legalized extortion. So it's very, very attractive to attorneys. There are many attorneys making very good money out of these cases. So they're looking for who their easiest targets are. Well, who are the folks that are have the hardest time in complex regulatory environments? It's our smaller family businesses. So that's why, I have great concern for our family farms about these things.
Yeah. So anything else about what it looks like in litigation when you actually get into the nuts and bolts of being in court?
Well, the California courts have tended to be very unfavorable to employers in these cases. And we've reached a place, because there's so many of these cases now, that we have courts that are making law for industry in ways that we never anticipated would happen. And it's ways that it's not really intended to happen. So, for example, in agriculture, we had an issue a number of years ago where two courts decided cases in unrelated industries. One was a mechanic shop, Mercedes mechanic shop in Beverly Hills, of all things. The other was a Safeway truckers, like long haul truckers for Safeway grocery stores. What this was about was per unit pay as opposed to hourly pay. So these Mercedes mechanics were paid by the repair. There was a book value. If you ever worked in the auto industry, there's a book value to these repairs that is from a centralized system where the manufacturer says, hey, if you're doing a brake system on this model of car, this is what you charge the customer for it in terms of labor and parts. And so these mechanics would make a rate that was based upon what that value was per repair, not per hour.
Right.
Now, these are Mercedes mechanics in Beverly Hills. These guys were making phenomenal money, right? They might only do one repair a day, but have you ever had a transmission repair on a Mercedes Benz? Right? If you have to ask how much, you shouldn't be owning a Mercedes Benz.
Exactly.
Right?
Yeah.
So these guys were making very, very good living. But there was a lot of time where they had downtime where they weren't working on cars, and they'd sweep up the shop, or they'd have meetings, or they'd hang around and wait for the next cars to come in. There was a lot of downtime on the job. Well, the court decided that downtime all had to be paid at minimum wage. That the amount of time spent, the amount of what they were being paid for working on the car could only be applied to working on the car. You couldn't average it over their hours, because that's what the shop was saying. Like, look, this guy's making, $1,200 a day. We don't have a minimum wage problem here.
Right. Yeah. We're exceeding that value, the minimum wage. Yeah.
But the court said, oh, yes, you do. Because that value only applies to the time he spent on that repair. And the rest of the time of the day, he wasn't being paid at all. So there's minimum wage violations and penalties attached to that.
Yep.
What that trickled down to in agriculture is we have a lot of folks in our fresh fruit and produce industry that are paid per unit harvested, what we call piece rate.
Yeah.
Right? Tomato workers paid per bucket of tomatoes. Strawberry workers paid per box of strawberries. We see it all across these industries. Well, the labor commissioner, the state authority in charge of these industries, had told all of these folks, and I actually had a case going on at the time, and we had subpoenaed their information they used to train their own auditors. They had trained their own auditors in payroll to average the person's piece rate earnings over the day. Because like in tomatoes, a good tomato picker would average over $20 an hour if you took their total earnings for the day divided by their hours worked.
Sure.
But now all of a sudden, anytime they're not spending actually picking tomatoes is uncompensated time, and we owe them minimum wage. If they're washing their hands before they get in the field, we owe them minimum wage for that. Their little 10-minute paid rest breaks, we owe them, according to the state now, their average rate of when they're picking tomatoes during that paid rest break. So we've got 20 minutes a day that we owe them this hourly rate on.
Yep.
Set all these industries completely upside down because of 2 court decisions. That this type of pay could not be averaged over any amount of time.
Yep.
Left agriculture, who was in compliance with what they'd been told by the state of California, facing hundreds and hundreds of millions of dollars in liability that they could not defend. Because courts don't make new law, courts tell us what the law already was. The state labor commissioner has no authority to tell us what the law is. The court's determination overruled all of that.
Right.
And they ended up having to come up with a legislative fix that required agricultural employers to pay millions and millions of dollars into a fund administered by the state that was supposedly distributed to employees through a process that was basically, the whole purpose of it was to just prevent this avalanche of lawsuits that would be indefensible that were coming.
Interesting.
And of course, we see very little coverage of these kind of things, but I mean, these are catastrophic impacts on industry as a result of this type of collective liability, where one person can stand in and represent the interests of, hundreds or sometimes even thousands of people in high labor industries.
Well, if you filter that down, I mean, what does it look like? What kind of fines and penalties and fees could one family farm face in a case like this?
It's rare that one of these things, I mean, if you take a farm with 25 employees, so not large at all, it would be rare for a case like that to be able to be resolved at an overall cost, even with an early settlement, of under hundreds of thousands of dollars. And I'm talking about attorney's fees to hire your own attorney, what it takes to settle the case, what it takes to navigate through that process. These are problems that are measured in the hundreds of thousands of dollars, even for our smaller employers.
Yeah, and so that's going to make anybody shrivel having that kind of liability.
Well, yeah, I mean, especially it's hard enough for farmers as it is. And, of course, in California, especially, our farmers are dealing with a difficult regulatory environment with water, with air quality, with pollution, with land use. I mean, on so many different things, with livestock, we have, animal treatment issues that we have to deal with. We have so many different regulatory management issues. Labor just becomes one more that piles on it, but it's one that can have catastrophic consequences that I think we need to find a way to protect folks against.
And so right now it sounds like self-insurance has been a primary way family farms have been dealing with this, right? They're taking their cash position and paying for it because there's not.
Well, unfortunately, we're not seeing enough of that, I think.
Uh-huh.
I think that's a potential solution here, is when there's not something that's available within the commercial insurance market, what other options do we have to protect against this risk? And so, what I would tell a farmer is that, right, it's like hedging your positions in certain supplies that you need or commodities that you need, right? You're betting against future risk in ways that are going to protect you in the future. I think these type of self-insurance plans are ways that you can do that, and ways you can do it with your own money. So it's not like, I mean, in many ways, I think it's preferable to commercial insurance, because if you don't use it, it's still there. If that catastrophe doesn't hit, the money is still there, and it's still yours in many ways. Whereas in the commercial insurance environment, right, you pay premium, you never have a claim. There's no other way to make beneficial use of that asset anymore. So I think there are ways these things can be used creatively for employers in the farming industry to set aside funds to protect themselves against some of these risks that exist in an environment like California.
Yeah, so there's really 2 options. They can either stockpile a whole bunch of cash, hundreds of thousands of dollars of cash, or take advantage of something like a captive insurance program and then hope that they don't have to use it. But if it does happen, then they have some insurance that's typically not available to them.
Yeah, I mean, even just to be able to navigate through that cost of, I mean, one of the things that happens in these scenarios is, and it's one of the reasons why this sort of litigation makes me unhappy is years ago when I first got involved in it, we used to argue a lot about the merits of the case with the other side.
Mm.
We'd collect evidence even for these mediations, and we'd bring in witness statements, and we would do all kind. If we thought we had a good case and they wouldn't listen to us, we would take a few depositions before a mediation and let them see what the testimony would be, and that would work. Like we could like in traditional litigation, we could show the other side, hey, your case isn't as good as you think it is,
Right?
and that would bring the numbers down. Over the years, one of the most discouraging things is in these mediations, we almost never talk about the merits anymore. You'll have mediators walk in and they'll talk about the market value of these cases. And I'll be like, market value of a lawsuit, doesn't it matter what the evidence is? Doesn't it matter what the truth is?
All right.
And it's shocking how little it matters.
Huh.
Because they're just trying to figure out what's the number that everybody writes a check and everybody goes home. I mean, it's a horrifying process for, anyone who is seeing this, who's been through it, is going to be nodding their head about how horrifying this process is to sit through. And I've sat through it with more farmers than I care to count. And in their world, which is a world where things generally make sense and you only do things for reasons,
Yeah.
it's a horrible experience to watch them see this unreality of a mediation process where you're just whittling down these numbers. And oftentimes the only leverage you have is by showing you can't afford to pay what these people are demanding of you. So we've done different strategies over the years for clients to essentially segregate assets in ways where the business entity in question can look as unhealthy as possible.
Mm-hmm.
So you can confidentially disclose certain financial information in a mediation to convince the other side, build yourself some leverage based upon, essentially economic capacity. Which I think this type of captive insurance program is potentially a way to set aside money to deal with these types of risks without giving up that leverage. Whereas if you set aside tons of assets, people aren't stupid. If you say, hey, we can't afford to pay, they're going to say, prove it. And if you're sitting on a bank account that is a bunch of cash in it, they're going to say, well, you can't afford to pay. Look at all you have saved. I mean, it's that gross.
Yeah.
That's brutal.
Well, also keep in mind too, that if you are just putting aside money, right, for a rainy day like that, those are after-tax dollars. That's
Correct.
a huge problem in California, right? With captive insurance company in place, you're putting those dollars away pre-tax, and of course they're gaining interest. So you have a separate entity that protects your parent company in a much more tax efficient way for the entire for your global concerns, meaning your parent company and your captive company.
Well, and I think to the extent you have a third-party claims adjuster working on those captive claims,
Right.
you also have better odds of having a claims adjuster that's going to be working in alignment with your interest, because in the end, they work for you.
Well, actually that's a really good point that we try to make is, if you have traditional insurance, you may have an agent that will go to bat for you, but ultimately the parent company, they don't want to pay that. That's their money that comes out of their top line.
Yeah,
So
it's not your agent when it gets to litigation you have to concern yourself with. It's the person that the insurance company assigns to the claim.
And they're looking for an excuse to not pay the claim.
Yeah, I mean, a lot of times, I've handled a lot of litigation where an existing client gets their insurance carrier to approve me to handle the case. And usually insurance carriers don't like to do that, because oftentimes they want the litigation to go forward enough where they're actually gathering evidence that enables them to either deny or limit the scope of coverage.
Sure.
Right.
So I've had fights before in cases where I knew there was liability and I wanted to get into a settlement negotiation quickly, where the carrier would tell me, no, we want you to take all these depositions before you have that negotiation. When I know the only benefit to that is for them to get more clarity from where the liability arises, So then they have a hook to hang their hat on to say, oh, we don't have to cover that.
Right. They get the
Right.
leverage.
So,
Whereas
again, people are going to act in their own interest. This is not even, I'm not trying to disparage the insurance industry, right? But
Oh.
they are businesses on their own. And when they're
That's
a
right.
separate entity with their own bottom line, like that's their whole incentive program is based upon, we're going to try to limit the scope of our coverage. That's how
Right.
they make more money off of premium. It's not
And-
faulting them to say that. But
Right.
this is unique because that circle is closed within, the incentives are all aligned with your business. And when you're talking about confronting a risk like a large scale litigation like this, it's much easier to manage that when you have that circle closed with a single purpose of how do we protect the underlying commercial enterprise.
Right. The with a captive, it's the claims process is completely turned around because yes, if one of our clients has a claim, we look at that claim, but we're looking for excuses to pay it. It's the client's money, right?
Right.
It's our money. So we're incentivized to pay those, to approve those claims. What we're in place to do is to make sure that the claims are legitimate and won't get the client in trouble with any regulatory body. So if, they make an out, we have a $200,000 claim, we want our captive to cover, it can't be a dinosaur attack, right? It can't be something absolutely,
right. Right.
So as long as it passes the sniff test, and we want the client to be paid. That's their money, right?
Well, what I'm really talking about is not just laying down and paying claims. What
Yeah.
I'm talking about is the insurance side of it working in cooperation and collaboration with the defense side of it to both minimize cost as
Mhm.
well as make sure that these risks are confronted.
Mhm.
So, there are times when we're dealing with a commercial carrier as a defense attorney in litigation that we see the carrier's interest butting up against the client's interest, and you're almost negotiating with the carrier at the same time you're negotiating with the other side.
Sure.
And I've worked with clients who've been in the captive scenario, and it's actually much more productive from the defense side because you can talk to the folks on the carrier side and use them essentially as a strategic partner in how do we protect the enterprise, and sometimes that means defending the enterprise.
Mhm.
I mean, I had a case a few years ago that we litigated for, man, I want to say 8 or 9 years because we felt there was no liability whatsoever.
Mhm.
And the plaintiff's theory was based on fantasy and not reality.
Mhm.
And the other side litigated with us extremely aggressively. That client was in a captive scenario. So it was very easy for me when the person who was responsible for the claim was an attorney that worked for the third party claims administrator. But this lady understood exactly what we wanted to do. And so it wasn't like we had to struggle with them to get them on board with what we wanted to do and how we felt money should be spent.
Yeah.
And so it just made things much easier and much more efficient in a situation that was a very messy piece of litigation that did not end up in a settlement. We got that case dismissed at the trial court, and then they appealed that, and we had the dismissal upheld on appeal. So we fought that thing all the way down. And what was interesting about it is one of the things the client was thrilled about was the captive used us to defend the thing to the bitter end, and we ended up prevailing.
Mhm.
There was another entity that was owned by the same folks that was involved in that litigation that had commercial coverage, not the captive coverage. And the commercial carrier paid several $1 million in settlement in that case.
To their captive.
to the other side, to the same people that the captive paid zero to.
Right. Nice.
Because we successfully defended the case.
Oh, gotcha. Yeah.
And the way it works with commercial insurance is if they want to pay a settlement and the client doesn't want to pay it, which was the case here, I had to tell the client, don't get in the way of that, because if the carrier wants to settle it and you interfere with that, they don't have to cover it anymore. And now the liability becomes yours because they in their assessment decided to settle and you said no.
Right.
Whereas with the captive on our side, there was no challenge in getting the captive to understand, hey, look, we're going to fight this thing to the bitter end, and here's why. And they obviously understood the merit was there, but they weren't aligned with our client on that.
Gotcha.
Whereas on the other case, the carrier got cold feet and decided to just write a check to make it go away, which for our client, as a matter of principle, was like, wait a minute, why do I have insurance for you to just write that guy a check when they don't have a case against us?
Right.
So I'd be curious to know on the on the commercial insurance side, after that settlement, what happened to their insurance rates?
Well, they went up, but they actually the client decided to no longer do business with that carrier and rolled that other entity into the captive.
Right. Nice.
That was smart.
So that was earlier in their involvement of captive. So they were sort of experimenting with it on one of their business entities that was related to each other. But it was, to me, it was a great object lesson in when you're within a captive, even if what you decide to do is fight what you think is a meritless case, as was here, you will be in alignment with your insurance carrier on that, because your insurance, unless you're doing something really harmful, as you mentioned earlier, where you're just going off the reservation, you really have more control in telling your insurance company, no, we should fight rather than settle.
Yeah.
Whereas this commercial carrier made a commercial decision, probably based on a much bigger risk management picture than this single account.
Yeah.
We're going to write this one off and we're just going to write a check and make this one go away.
Yeah. You have much more control because you're the owner of the captive insurance
Right.
company.
And if you as the insured have that relationship with a commercial, a true commercial carrier, and you say to that carrier, no, I want to fight, we don't want you to settle this, you're now risking losing the value of that coverage.
That's right.
Unless you go along with a settlement that you may disagree with. And, maybe it's because I've been in agriculture, I've represented a lot of principled people who don't want to settle things.
Right. Yeah, that's right. Yeah.
They're willing to fight. Yeah.
Sometimes they'll even sue attorneys that make false claims against them, from what I understand, Mr. Johnston.
Yeah.
Well, as we're wrapping up here, am I standing on firm ground when I say it'll probably continue to get more complicated for labor law in the state of California?
Well, it's funny that you asked that, because one of the things I do in agriculture is I teach licensing classes for farm labor contractors. And one of the things I do when I teach those classes is I always ask the students how long they, how many have been a contractor more than 10 years, more than 5 years, so on.
Yeah.
And then I asked the ones who've been contractors for a long time. I said, you guys have been here have been doing this the longest. I see you every year here. Does it get easier or does it get harder? They all laugh and go, oh, it gets harder. Right? I mean, the reality of doing business in a state like California is that it's a very challenging place to do business. It can be a very rewarding place to do business.
Sure.
But it has a lot of challenges and a lot of risks. And the people that survive and the people that thrive are the ones that plan well for those challenges and plan well for those risks and are able to manage those bumps in the road when they come up.
Right. And also the other challenge is that insurance companies have been leaving the state of California. So there seems to be less coverage also.
Yeah, well, the commercial insurance marketplace gets more and more difficult all the time in California. And we've seen a resurgence in a lot of the discrimination and harassment claims in recent years as well. As the legal environment oftentimes mirrors the social environment. And, we are in an era now where there is a lot of attention on a variety of different types of discrimination. Yeah. And we have an ever expanding scope of what categories are protected under civil rights laws. That makes, again, everything more complicated and more fraught with risk. And we've seen growth in those types, what were sort of the old school employment litigation claims, discrimination, harassment type things are growing now. Now, those things traditionally have been covered in the commercial insurance market by what's called employment practice liability insurance. But those policies, I think, are getting more expensive. And with fewer carriers, it's a less competitive marketplace. And I think, for folks for whom it makes financial sense, I think there's a lot of advantages to using captives to provide that kind of protection. That clients that I've worked with who have shifted from commercial insurance to captives have generally been very, very pleased with the results, and none have gone back.
Yeah, that makes sense. Or just for all the reasons that you've laid out in the last hour. And Patrick, is there anything else that you wanted to ask Tony about before we wrap it?
No, well, I mean, the only thing I would say is, Tony obviously is looking at this from one end of the client's experience. But when we were talking about how you have this pool of money that gets cut up, a lot goes to the attorney, some goes here, and very little bit goes to the employee. Remember, that pool itself is filled by the farm or the employer.
Yes, all of it comes from the employer.
Right. It all comes
Right.
from one
Right.
spot. And
Yeah.
that's what we are trying to help farmers and farming families. That's the risk we're trying to help them mitigate by putting them in a position that if that day comes, they are in a much better position and their business is not going to be threatened to the same degree. The second part of this is, if you have that coverage, you become a less inviting target for these attorneys because they, as Tony mentioned, this is a leverage game. And now when you have coverage, they have less leverage. And so, it makes it more likely that they're going to go down the street to the next farm. So, but if that day
Well,
comes.
and also, it gives me the ability right out of the gate as an attorney to tell the lawyer on the other side, hey, we've got coverage that's got this amount of limits.
Yeah.
That's the amount of money we have to play with. So we gotta work something out within that.
Yeah.
And start trying to push them down from there to see what you can do to, of course, protect your reserve as much as possible. But ideally, it's like playing with house money, but it's yours.
That's right.
Right.
You know what I mean? Like,
Mm-hmm.
I think there's a lot. I think there are ways that this can be utilized that we haven't even scratched the surface of yet.
Right.
I truly think a lot of folks are not taking advantage of it in ways that they could. I mean, I think for some folks, just, we've seen a very volatile insurance market in California. As you mentioned, carriers come and leave the state. And I've seen periods in my career where things got really, really tight in terms of what the insurance market looked like.
Yep.
Being able to have that stability and that assurance that your coverage isn't going to get, you're not going to get a notice of termination because your carrier is leaving the state.
Yeah.
Right. You've got your coverage in place, it's stable, and you've got control of it. I think that's very valuable as well.
And keep in mind, like Tony said, when you have a captive, if you don't have a claim, those premiums stay in the captive that you wholly own, and those grow over time. So in any given year, if you've been bumping along and contributing to your captive for 10, 12 years, and something like this comes to your doorstep, you've had all these premiums that you've been plowing into your captive that have been gaining, they've been compounding over time. So now that war chest that Tony talks about, that gets a lot bigger over time. It's not like traditional insurance where each year you pay a premium and you're starting over, right?
Yeah.
You have this, whatever it is, $500,000 in coverage, $1 million in coverage. Bang, the clock stops, you got to pay another premium. It's not how it works with captive. You're keeping those premiums in there year after year after year. And if you hopefully you never have to use them, and that money's all yours.
All right. Well, Tony, thank you for your time today. Appreciate you spending time with us at 3F Captive Services.
Thank you very much, Tony.
Take care.
Yeah. All right, guys.